United States versus Davis. All right, Mr. Burns.
Good morning, Your Honors, and may it please the Court. I'm Thomas Burns, and I represent Mr. Davis. Let's talk about sufficiency and multiplicity. With respect to sufficiency, I think the parties agree on maybe four things. I think we agree that the evidence was sufficient to establish mens rea. I think we agree that the actus reus is limited to the October 7 call. I think we agree that the standard for reviewing that October 7 call is an objective standard rather than a subjective standard. And I think we agree that it's not illegal for one to seek to obtain from a witness a statement of the facts as he believes them to be. And that's the Eighth Circuit's decision in Harrington against the United States, and then also this court's decision in United States against Brand. But where we disagree is whether that actus reus meets those standards. And when I review the Davis call of October 7, I think he's saying five things. I think he's saying, what will your testimony be? I think you're lying. If you lie on the stand, I'll go to jail for a long time. Instead of lying, you should tell the truth. And because I think you might lie, I won't have my attorney, the man, call you as a witness. And it's our position that that's not sufficient to establish the actus reus element under Harrington and Brand. And in fact, when I kind of summarize the call in that fashion, it seems to me very similar to the kind of conversation a law enforcement officer would properly have with a witness in a criminal case. It's like, well, what's your story? I don't think your story's right. If you don't tell the truth, then this other person's gonna get off. You should tell the truth. And if you don't tell the truth, we're not going to call you. And that's commonly done not only on the defense and prosecution side, it's done in many types of cases. And that's what this court recognized in Brand. It says, well, this is potentially creating dangerous precedent if we allow a conviction under 1503 to go forward based on this kind of conduct, because it happens all the time, and we don't want to criminalize that. So that's our position on sufficiency.
Several of the cases say that 1512 doesn't cover just encouraging someone to perjure themselves.
Right. Are you getting to the multiplicity part, or you're talking about sufficiency?
Well, I'm still trying to understand the gaps between the two, 1503 and 1512.
Okay. I guess in my mind that's the multiplicity thing. So if you wanted to go to that, that's fine. I think for multiplicity, the parties agree that you need to apply Blockberger. Our position is that you need to apply Blockberger, understanding the historical context of how these two statutes interacted. 1503 in some form or another has existed for almost 200 years, and originally it dealt with judicial officers, jurors, and witnesses. And then in 1982, you have this amendment, or not an amendment, but it's an act called the Victim and Witness Protection Act. And then we move all this witness stuff over to 1512.
I understand, and that's what the Second Circuit said. But almost every other circuit to consider the issue said just because they created a separate witness statute doesn't mean 1503 loses its
Right.
scope, what it was, as it relates to witnesses.
Right.
What I'm trying to understand is the scope of 1512 versus 1503. So a couple of the cases that everybody cites and talks about say that the reason you're allowed to have both is because 1512 doesn't cover just encouraging a witness to perjure themselves. And that in that case, 1503 has to be the vehicle.
Right. And here's how, and I actually think, the more I thought about this, that really none of the courts that have addressed this question have got it right. Even Hernandez in the Second Circuit. And the 1988 amendment's very important in that regard. So initially you've got this statute, Congress moves the witness stuff over to 1512. Hernandez says, that means that witness stuff is only prosecutable under 1512. And then Wesley, which is a Fifth Circuit case, says, no, that can't be right because then you're creating this gap between the statutes. So Congress must have meant to leave the witness stuff within the residual clause. And then there's a circuit split that erupts at that point. And then the 1988 amendment happens, and instead of it just being witnesses who are threatened, it changes it to corrupt persuasion. So at that point, I think the gap got closed, and the Second Circuit addresses the question again in a case called United States against Masterpaul, and they say, okay, well, the gap is closed. That confirms that our understanding in Hernandez was correct, and therefore all the witness stuff should be prosecuted under 1512 and not under 1503. I think the way, had I been handling this at the time, I think Wesley got it right in 1982 that Congress didn't intend there to be a gap for corrupt persuasion cases of witnesses. But then once Congress closed the gap in 1988, I think it became clear that all these cases should be prosecuted under 1512. All the witness cases should be prosecuted under 1512 rather than 1503. And the residual clause is only there to catch any kind of case that isn't otherwise caught by 1512.
Okay, so it's your view that 1512 would encompass merely encouraging someone to perjure themselves?
Yes, because that's 1512, as it's written now, captures corrupt persuasion cases, and I think that would be a corrupt persuasion case where you're saying, this is, your story is A. What I really want you to do is say B, and here's like some money to do that, or some other way of persuading the person that's what they ought to do. So what I think.
What do we do? I mean, I know Moody doesn't address the multiplicity issue, but Moody does say that 1503 is still applies to witnesses.
Right, and Moody is a problematic case for me. But Moody is a 1995 decision, but it's dealing with conduct that happened in 1985 and 1986, which took place before the 1988 amendment. Now, Moody was clearly aware that Congress had amended Section 1512 to include the corrupt persuasion stuff because it cites the Masterpaul case, and Masterpaul, rested its ruling on the 1988 amendment. But to the extent Moody was addressing the meaning of the statute after the 1988 amendment, I think that is dictum. I think what you're bound by is like the period between 1982 and 1988. Moody says this is, there's a gap. We reject Hernandez, and therefore the residual clause still captures witness stuff. But because it doesn't talk about that conduct, because it's addressing only the case that's before it, it's not really answering the statutory interpretation question that I think is presented here. So my view of what the circuit split is right now is the Second Circuit's decision in Masterpaul and the First Circuit's decision in Lamour, because both of those are after the 1988 amendment.
But Lamour actually said the 1980 amendment.
It does.
Supported the opposite.
It does, right. Correct.
Basically, what you're saying is that the real circuit split is right now between the First Circuit and the Second Circuit.
It is, right. And that's why I think Moody doesn't control the question, because it's distinguishable, because it's dealing with conduct that occurred between the enactment of the statute, the enactment of 1512 in 1982, and the amendment of it in 1988. If you disagree and you say that Moody is not distinguishable on that basis, I don't want to say that my ship is sunk, but it's difficult at that point for me to win. Then the only way that I can think of to distinguish Moody is to say that that's a sufficiency case rather than a double jeopardy case, but I don't know how that would really get me to a different result at that point. So what I need to hang my hat on is this idea that it's not addressing the statute after Congress amended it in 1988. So if you understand the statute the way I do, which is that basically everything today, everything that's witness related is prosecutable under 1512. The residual clause exists only to capture some kind of case that isn't otherwise captured by 1512, which I think there is no such case now. That's why I see there's a double jeopardy problem here. So in other words, I see a 1503 witness corrupt persuasion case as a harder to prove but lesser included offense of 1512b1. So
I thought you pretty much conceded in your brief. I'm looking back on it, that 1503 has an element that 1512 doesn't have, which is knowledge of the pending judicial proceeding.
that's correct.
Okay.
That's correct. But what I'm saying
I
is,
don't know how, when they got different elements.
right, and that's why
What you're arguing here, tell me what you're arguing here.
my argument is to do the Blockberger analysis in
Right.
this case, you need to understand the historical context of how these statutes
You can see
developed.
one of them has a different element from the other one. You don't debate that.
I can't, because
Okay.
they do. But my point is that element, it depends, I guess, on the scope of the review that you look at. Like if you look at, if you take a
So what are you asking the court to do if we were to accept your argument that this is even a problem?
I'm asking you to reverse the 1503 conviction because it should have been prosecuted only under 1512. That's what,
Even though 1503 has an element that 1512 doesn't have, an additional element.
correct. But the question, remember that Blockberger is ultimately a rule of statutory construction. And so what we're really trying to get at ultimately is what did Congress intend when it enacted 1503 and then enacted 1512 and then amended 1512. And I think what Congress showed that it was trying to do is like in 1982, it created this gap, which was, like a whoops, like we created a gap we didn't mean to. And then in 1988, they amended and they closed the gap. And I think that's, when you look at that, that's what Congress's real intent was to do. And so
1512, even though it doesn't, 1512, it doesn't have an element that 1503 has, but there's no way you could be convicted under 1503 without also being convicted under 1512.
that's my point, right? But it's odd because they have different penalties, or maximum penalties. 1512, the maximum penalty now is 20 years, I believe, and 1503 is 10 years. Back in the 80s, it was 5 and 10. So right now, when you're talking about a corrupt...
Why do you want to vacate 1503 and say it's only 1512? Seems like you'd want to do it the other way.
I would like to do it the other way, but I think it was properly prosecuted under 1512. Unless you're willing to give me that, but I don't think it would be appropriate to ask for that in this record. It would be better, but I think it's proper. I think what Congress meant to do is to have these cases prosecuted under
I don't
1512.
know about, you can't be guilty of one without being guilty of the other. There are a lot of crimes with overlapping
And
things, even conspiracy to possess drugs with intent to distribute. If you're guilty of that, if you're guilty of the substantive offense, you could argue, well, if you're guilty of that, you're guilty of the conspiracy too. There are lots of crimes like that. I don't know why, if you can be guilty of one, you're without being guilty of the other, why that matters. What tells us that matters? Where does that come from?
well, I think it has to do
Instead
with
of looking at what the elements are of the different crimes.
right. I think the answer to that is kind of captured in the scope of review that you're going to do with what the crime really is. And here, I have, I think, a narrower scope of review than perhaps the government does. I see the crime here as corrupt persuasion of a witness. And so if that's the crime, then whenever you have corrupt persuasion of a witness and you get a conviction under 1512, you're definitely going to get a conviction under 1503 or you'd have an inconsistent verdict. Because at that point, it's easier to prove 1512 than it is 1503 because 1512 doesn't require pending judicial proceeding. It just requires an official proceeding, and there's another. I think that was the point that I want to make. Okay, so
didn't really understand Lamour's reference to the 1988 amendment as somehow supporting the conclusion that they reached.
That's the problem that I have with it too. It's like the opinion is beautifully written, everything's going great, and then there's the 1988 amendment, and it's sort of like almost a throwaway paragraph where I'm going to mispronounce the First Circuit, Judge Bowden, he says no, the 1988 amendment supports my position too, and it's like, well, why is that so? I don't understand. So I felt that part of its the court's analysis was
Statutory history section says, and would allow such prosecution in other circuits to be brought under Section 1512 rather than the catch-all provision of 1503.
I'm sorry, could you say that again?
And he quotes from Senator Biden, and he said it's intended merely to include in Section 1512 the same protection of witnesses from non-coercive influence that was and is found in Section 1503. Of course, they add the "and" is in,
Right.
without saying emphasis added. But, and then it says, it would permit prosecution of such conduct in the Second Circuit where it's not now permitted, and would allow such prosecution in other circuits to be brought under Section 1512 rather than the catch-all of 1503. To me, that implies that they're saying we are moving it all over here.
Yes, that's how I read it.
Okay.
So I guess to sum it up, I think it depends a lot on what you define the crime to be. If you take a narrow view like I do, that it's corrupt persuasion of a witness, I think the Blockberger analysis goes in my favor. If you take a broader view of what the crime is, then it becomes more problematic for me. And that's sort of ultimately where the analysis goes, I think.
I think you say some rebuttal.
Thank you.
Thank you, Your Honor. Karen Hopman for the United States. Your Honor, I'm having a difficulty with the actual scope of review because Hernandez as a sufficiency or as a statutory interpretation question was never argued below and is certainly not argued in the briefs. If we were to put aside all of the multiplicity cases, including Lamour, including Moody, et cetera, any case that bears on it, and go directly to what the issue actually is, which is multiplicity, you would look simply at the elements of the statutes. As Your Honors, I think variously have pointed out, there is an element in each statute that does not occur in the other, and that is the end of the Blockberger analysis. Now, were we to return to sufficiency, and again, this Hernandez argument is new to me, because using Hernandez, which was a sufficiency and statutory interpretation case, to argue multiplicity fails. Why? Because Hernandez never said that it was interpreting statutory intent to avoid a multiplicity problem. So it's hard for me to see how we can tie all of these cases together. As far as sufficiency, we would not agree that a, quote, actus reus is what is at issue here. The actus reus would be the actual actions of the defendant. I understand that the appellant originally argued corrupt intent. When we responded to that with the appropriate cases, they changed their mind and said, no, really, under Harrison, it's actus reus. Well, the problem is that Harrison is clearly a corrupt intent case. The same as is the case that we were provided this morning, the Brand case. Those are both, again, corrupt intent cases. The question is whether there has been undue influence or corrupt intent brought to bear. And the evidence that we have in this case of corrupt intent is not only this gentleman's words to his 10-year-old daughter during the 10-7-14 call, but we also have the fact that he was using somebody else's PIN number to make that call, covering it up. We also have his other conversations with the mother afterwards during a three-way call, during which he called the child onto the phone again and told her that she was basically going to have to choose between parents. We have plenty of evidence of corrupt intent.
Well, and all of that, though, I understand you don't think we should be looking at how the interplay between the statutes, but except for through the multiplicity test. But assuming that we were, all of what you just described would be chargeable, prosecutable under 1512, and the government wouldn't even have to prove knowledge of the ongoing proceedings, right?
Correct, but it's also chargeable and provable under 1503. And the question, again, is whether there was sufficient evidence to support both. And again, there was never an argument that we could not charge under one because it only must be under the other. The argument was that it was insufficient under either or both at various times, and a multiplicity argument. So we certainly have evidence under both statutes on the facts of the case. And those facts do not, this was my point at the beginning, those facts do not affect the legal analysis of multiplicity. I don't see how, and we still don't have, after oral argument from the other side, we still don't have anything pointing to the fact that we could somehow look at the actual conduct to determine whether there's been a double jeopardy problem here. That's a strictly legal question under Blockberger. It is answered by looking to the language of the statutes, and it's answered rather easily here. We then delve into the sufficiency. Again, there has been no Hernandez-type argument here whatsoever. And if there were, we certainly would have responded to it, and we certainly would have taken the position that we can prosecute under both statutes as we did, but it's not even before the court. So then we're back to normal factual sufficiency, and all of this evidence was sufficient for both 1503, the pending proceeding element especially, which is the unique element, and 1512, the unique element of the another person, because this was indeed witness tampering. This was obstruction by attempting to persuade this child not only to give a conflicting statement or to give a false statement, as in the Brand and the Harrison cases, but actually not to take the stand. And again,
What is the distinction? You know, when a lot of these cases talk about just merely encouraging someone to testify falsely, not taking the stand, do you view that as different than saying, don't testify against me?
well, it's a tougher question when you have the don't testify a particular way, because you certainly do have the right to go out and seek a truthful statement, or even a statement as you think the case evidence shows. And that's what happened in both Brand and in the older case in Harrison. Now, the court used that evidence to talk about corrupt intent, to discover whether this person harbored an intent to corrupt the proceedings, or in our case also to corrupt the witness, basically. But it is an easier case in our case because he didn't even want her on the stand. That was the obstruction. He was not merely saying, I want you to say this, and then the corrupt intent would still be there, but he was saying altogether, I don't want you anywhere near that stand because you're going to then have to choose between me and your mother. So it's an easier case for us. Your Honors, I did not hear any argument as to the rest of the issues, and therefore we would rest on our brief unless you have any further questions.
I have a question. I looked for the letter that was excluded at trial. I read the birthday card that was admitted where the mother is saying, I'm sorry for what I did and all this, which goes to the defense of she was lying and so forth. But the letter that was not admitted is not in the record. Did you look for it?
I looked for it as well and did not find it in the record. There was
Okay.
mention of a letter at sentencing as well, and perhaps appellant would know. I do not believe that is the same letter. Because it was not admitted, I did not find it either, and I had to go on what was in the actual
It's on the
transcript.
exhibit list, but it was not admitted. And
Correct.
so in the box of exhibits, it's only got what was admitted, not what was excluded. So I don't know if the trial lawyer didn't perfect the record by tendering it to the court so it would be in the record, or what happened?
That would be my inference, but I'm certain that the appellant, if there is a more favorable
That
inference. could
issue
tell
is
you.
there, but I couldn't evaluate it because I don't know what the letter says, and whether it's redundant of the birthday card, and whether you had enough cross anyway on anger, and the card itself is pretty good for the defense, that she's saying, I'm sorry about all this. And
As is Takara Wilson's testimony, Your Honor, because I believe the counsel was reading actually directly from the letter when
Okay.
cross-examining her. And so the
you'd say it
statements,
came in anyway.
I'm saying that it was entirely, her testimony was entirely redundant of the letter because the letter was actually used to examine her to determine what she had said in the
Okay.
letter.
Thank you, that's helpful.
Thank you.
Your Honor, I'll look into that issue. Obviously, the trial lawyer needed to perfect the record, and I'm not sure if that happened, but I'll figure that out, and
You need to confer with the government about what
we'll
you
sort it out.
want to do, but it's not there, and it may not matter that it's there because of what she just said. So you may decide,
Maybe.
we can tell from that.
Right. I just wanted to highlight one thing. I think, again, we agree on this, that if you're just getting the witness statement, that's not a crime, or not one of these crimes. But the question then is the call with the additional things that he says, is that close enough to Harrington and Brand that the evidence was insufficient? I think you've got the tools that you have, that you need to resolve that question. You just, read the call and look at those cases and
Tell
decide.
me why it's insufficient, because he's clearly saying, I don't want you to testify. Why is the evidence insufficient?
Right, and remember, it's an objective standard. I read the call, and I think it has to be my position that this is the only way to read the call, but my reading of the call is he's belly aching. He says, "What's your story?" Then he says, "You're lying," and then he says, here are the consequences that will happen if you get on the stand and testify, and that's going to put me in jail for a long time. I don't think that that's corrupt persuasion of the witness, because almost immediately after that, he says, "Never mind," and "Don't worry about it." He definitely says "never mind." I think he also says "don't worry about it." And so it's like after he's done with that venting or belly aching, he says, "Okay, well, that's
The
it."
question is it really for the jury to decide? Was there enough there to go to?
To go to the jury.
Right.
Right, because obviously the jury, returned a guilty verdict. And my position is, no, there wasn't
I'm not
enough.
going to argue about what's reasonable from that call.
Right, I understand.
I just wanted to know what your theory was.
Yeah,
Your theory is that was belly aching, nothing more. Okay.
right.
Got it.
And
In response to the question of whether Hernandez is really before us.
the argument I raised was a multiplicity one, and so the question is really, did Congress intend for there to be dual punishment? And I said no. That was the argument that I raised in the appellant's brief. I said no, Congress didn't intend there to be dual punishment. And then the Hernandez issue comes about because this is just like one other piece of information, one other piece of precedent that helps us get to that, or potentially helps you get to the conclusion that no, Congress did not intend there to be dual
I don't
punishment.
see Hernandez covered in the brief.
I didn't cite Hernandez in the first brief, right? I said these were the cases that are against me, and I think they're distinguishable. And then on the reply brief, I say this is what I think the circuit split is between Hernandez and some of these other cases. But that was, I think, consistent with the argument that I had raised before.
But
So,
the government's position is that below, the only thing that was argued was multiplicity. And if that's the case, all you do is the element-by-element analysis, and that's the end of the inquiry.
well, that's my position is you can't just do the element by element analysis, because you have to put it into context with what Congress was doing, and then you also have to define it narrowly. Now, if I'm not correct about those things, you'll tell me when you write the opinion. But our position is you got to understand the historical context, then do the Blockberger analysis, and then come, define it narrowly, do the Blockberger analysis, and then come to your conclusion.
I think we have your case.
Thank you.
You were court appointed. We appreciate your having.
Thank you.
Valerie, here's the PSI. From you.